everyone. We're going to go ahead and get started. I'd like to welcome Tass Welch from Community Christ Church in Milton, Georgia, who will lead us in the invocation.
Father, we thank you so much that we have so many freedoms, the freedom of speech, the freedom to assemble, the freedom to vote, the freedom to say the Pledge of Allegiance, and so much more. We are just so blessed. And help us never take for granted our freedoms. And Father, I thank you that in this town of Milton, in this city, that we have such a great diversity of opinions on things, because with the great diversity we can come to better understanding of each other, and we can live in a community that just has the ability to express and I hope respect each other, but also to keep going and making this place a better place. Thank you for the officials. I thank you for the staff that works tirelessly behind the scenes. I thank you for all that you have done in the city and that you will be doing. And Father, as people come to express their thoughts and opinions, help us to seek to understand. Help us to not put people down, but to express our own opinions and let that be. Father, again, I'm so grateful that we can meet tonight and that you are here with us. I ask this all in Jesus' name. Amen.
Amen.
I would like to call the regular meeting of the Milton City Council for Monday, June 15th, 2015 to order. Will the city clerk please call the roll and make general announcements?
Good evening, Mayor and Council. I'll be happy to call roll for the June 15th, 2015 regular meeting. I would like to remind those in attendance to please silence all cell phones at this time. Those attending the meeting who would like to provide public comment, either during the public hearing or during the call for public comment, you are required to complete a public comment card prior to speaking on an item. There is no public comment for consent agenda items or items under first presentation. Those called to speak will be taken in the order that the speaker cards are received by the city clerk prior to the beginning of tonight's meeting. All speakers will identify themselves by name, address, and organization if applicable. The City Council may allow public comment on either an agenda item or general public comment from a representative of such an organized group or association, provided that such an individual shall file a notarized affidavit that they have the authority to speak on behalf of said organization on a form provided by the city clerk prior to the agenda item being called. Demonstration of any sort within the chamber is prohibited, so please refrain from any applause, cheering, booing, outbursts, or dialogue with any person speaking. Please show the same respect to the person speaking that you will expect to receive yourself. Anyone in violation will be asked to leave. As I call roll this evening, please confirm your attendance. Mayor Pro Tem Karen Thurman.
Here.
Councilmember Bill Lusk.
Here.
Councilmember Joe Longoria.
Here.
Councilmember Rick Morick.
Here.
For the record, Mayor Joe Lockwood and Council members Matt Kuntz and Bert Hewitt are absent this evening. Would everyone please rise for the Pledge of Allegiance?
I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I want to thank everyone for coming tonight. We have several very important items on the agenda. As you can see, we do have a skeleton crew tonight, but it's that time of the year with summer vacations, so we want to hear what everyone's comments are going forward. So will the city clerk please sound the next item?
Our next item this evening is approval of the meeting agenda. This is agenda item number 15161.
Do we have any changes to amendments to the agenda item? Does council have any amendments to it?
No.
Do I hear a motion?
Mayor, Mayor Pro Tem, I move that we approve the meeting agenda, item number 15-161.
Second.
There's been a motion by Councilmember Longoria and seconded by Councilmember Moore to approve the agenda as presented. All in favor?
Aye.
Aye.
There's no opposition. Motion carries. We have any public comment?
We do not have any general public comment.
Okay, if we don't have any general public comment, we've got a full agenda, so I'm going to go ahead and waive the general public comment remarks. We will have public comment with each of the agenda items as they are sounded. So, moving on to the consent agenda, will the city clerk sound that item?
First item, approval of the May 18th, 2015 regular city council meeting minutes, agenda item number 15-162. Next, approval of the June 1st, 2015 regular city council meeting minutes, agenda item number 15-163. Next, approval of the financial statements for the period ending May 2015, agenda item number 15-164. Our next consent agenda item is approval of a Parks and Recreation Department facility use agreement and addendum between the City of Milton and NFL Youth Football League, Inc. Agenda item number 15-165. Our fifth and final consent agenda item this evening is approval of a Parks and Recreation Department facility use agreement and addendum between the City of Milton and Hopewell Youth Association, Inc. Agenda item number 15-166.
Madam Mayor, I'll move to approve the consent agenda as prepared by staff.
Second.
I have a motion to approve the consent agenda and second it. All those in favor, please say aye.
Aye.
There's no opposition. The motion carries. There are no items under reports and presentations, first presentation, or the public hearing, so we'll move on to the zoning agenda. Will the city clerk please read the zoning rules and sound the first item?
At the second regularly scheduled meeting of the month, the mayor and city council consider a zoning agenda. These items include rezoning petitions, modifications of zoning, use permits, and associated concurrent variances, in addition to ordinances, resolutions, and text amendments. I would like to acquaint you with some of the rules and procedures for this meeting. The applicant and all those speaking in support of an application will be allowed a total of 10 minutes to present the petition. The applicant may choose to save some of the time for rebuttal following the presentation by the opposition. Since the burden of proof is upon the applicant will be allowed to make closing remarks provided time remains with the allotted time. The city clerk will be keeping track of time and will inform you periodically of the remaining time for your presentation. Those called to speak will be taken in the order that the speaker cards are received by the city clerk prior to the beginning of tonight's meeting. Before beginning your presentation or comment, please identify yourself by name, address, and organization if applicable. The Planning Commission has heard the rezoning agenda items, and recommendations have been forwarded to the mayor and city council for consideration and disposition. The applicant shall not submit material to the council during this meeting unless requested to do so. When an opponent of a rezoning action has made within 2 years immediately preceding the filing of the rezoning action being opposed, campaign contributions aggregating $250 or more to a local government official of the local government which will consider the application, it shall be the duty of the opponent to file a disclosure with the governing authority of the respective local government at least 5 days prior to the Planning Commission meeting. A violation of relevant state statute constitutes a misdemeanor. Therefore, if you have contributed $250 or more to a council member and you did not file a disclosure prior to the Planning Commission meeting, the city attorney strongly suggests that you have someone else speak for your point of view. Our first zoning item this evening is consideration of RZ 15-08 to amend the equine garment fabrication use permit This is agenda item number 15099. First presentation was at the April 13th regular City Council meeting. It was discussed at the April 20th City Council work session. It was deferred at the April 27th council meeting. Ms. Kathy Field.
Thank you, Madam Mayor Pro Tem and members of the City Council. This is a text amendment that the Community Development Department recommends approval for. And by way of background, at the April 27th meeting of the City Council, the Council approved the proposed definition of equine garment fabrication pursuant to RZ 15-09 and allowed the use by right within the AG1 district up to 2,000 square feet pursuant to RZ 15-07. Further, at that meeting, the Council recommended that the use permit be deferred to the June 15th meeting to allow time for staff to amend the use permit to remain in the zoning ordinance and to require a use permit when an equine garment fabrication building exceeds 2,000 square feet. Therefore, staff has amended the use permit to be consistent with the Council's proposal. Additionally, the proposed amendment was presented at the May 27th Planning Commission meeting for their review. At that time, the Commission unanimously voted to recommend denial of the proposed amendment to the use permit. They expressed their concern that the proposed amendments would allow noxious uses such as tanneries and retail shops that sold unrelated items on the premises. The Planning Commission also stated that text amendments should not be initiated just for one or two situations. That is my presentation, and you should have before you the language for the proposed text amendment, and I'm happy to answer any questions.
Thank you. Are there any questions of staff? First, we will hear from all those speaking in support of RZ 15-08.
We do not have any public comment cards in support or in opposition, ma'am.
Okay. Do we have any discussions? The public hearing then is now closed. Is there a motion and a second?
Mayor, I move to approve RZ 15-08 to amend the equine garment fabrication use permit, agenda item number 15-009.
Second the motion.
Okay, there is a motion by Councilmember Longoria and a second by Councilmember Lust to approve RZ 15-08 as presented by staff. All those in favor?
Aye.
No opposition? Motion carries. Will the city clerk please sound the next zoning item?
Our next zoning item is consideration of RZ 1511 to create the Arnold Mill Form-Based Code, Chapter 64 of the City Code, Article 21. Agenda item number 15154. This was discussed at the June 8th Council work session. First presentation was at the June 1st City Council meeting. Ms. Kathy Field.
And if I could just interrupt real quick before Kathy gets started. I think this is on, maybe. This is one I think that before we get to a staff presentation, I think Councilmember Thurman had some comments to make before we get to that presentation.
Yes, thank you, Mr. Lagerblum. This, to me, this is a very big issue for our city because it is actually setting the direction for our entire quarter of the area. Personally, I believe this is something that ought to be decided on by 7 members of the council rather than just the 4 of us that are here today. I also know that this was a split vote on the Planning Commission. I believe it was a 4-3 vote, and that they recommended some changes. Personally, I believe this ought to go back to the community to let the community hear the changes that the Planning Commission has recommended, since it is different from what the community originally discussed at all their meetings. So I just want to get the input of the rest of the council to see what your thoughts are on this before we have a full staff presentation. Regardless, this is a public hearing. We will have everybody that has signed up to speak will have, plenty of time to speak. And their comments, even if this is deferred to a later date, their comments still will be part of the record, and we will take into consideration those comments. But I wanted to get the rest of the council's opinion on this subject.
I agree with your assessment. So I don't think that there's anything pressing in terms of us needing to vote on this today, and I would agree that makes more sense for us to present back to the community the changes that were offered up by the Planning Commission.
I'm in agreement with that, too.
I'm concerned with some of the inconsistencies in the terminology that we've used in this overlay as opposed to previous overlays, too. And I think we need to open up that discussion, further comment also.
Well, yeah, unlike the crabapple and the Deerfield, where we were kind of tweaking and putting a form-based code around existing development, this really is, we're laying out a plan for the entire corridor. So, and this is very important to the city.
I would agree.
Okay. Go ahead with your presentation, knowing that it appears to be the will of the council that we will probably be deferring it. So
Certainly. We do have Caleb Rassico, who is our consultant from TSW. Caleb, as you know, presented it at our workshop meeting. However, there were a few issues that have come up since that workshop that he wanted to address and provide you with some further information. So with that in mind, he has a very short presentation to address a few of those issues and certainly is available to answer any questions you may have as well. So with that, Caleb.
Thank you, Kathy, and good evening, Madam Mayor Pro Tem and Council. What I wanted to do this evening, as Kathy mentioned, was talk a little bit about, very briefly, some of the changes that have been made based on some of the feedback we received at the work session, just so we can keep you apprised of what some of the major changes are. I also wanted to remind the public and the council that, as mentioned, this code, from my perspective, has really been a codification of the vision of the Arnold Mill Road Visioning Plan. We went in good faith and read through the plan line by line and created a code that we feel adequately reflects the density, the land use, really the character of development within that plan. And of course, as part of that, achieves many of the unique goals of that plan: the preservation of open space and historic resources, the prevention of continuous commercial strip development on the corridor, and instead the concentration of development in compact walkable nodes, the avoidance of conventional pod subdivisions, and also, very importantly, avoidance of some higher density residential, things like townhomes or apartments. And so we've really crafted this based on those specific policy goals that were in there, which I think is always important for us to remember. And of course, did that using the template, as was mentioned, that was used in Crabapple and Deerfield. And also, just as a reminder, we also were very deliberate about making sure that all of these proposed code changes would really tie back to current property rights. And so as we looked at the current zoning that people had and we developed a regulating plan to codify that, we made a very conscientious effort not to downzone anyone. And so with that said, we did receive a series of comments from our work session last Monday. And I just wanted to point out what some of the major changes were that we made based on those feedbacks. The first was that there was some concern from members of the council that there's a provision in the code that says if you are zoned in a node, meaning you are zoned T3 or T4, you could have commercial uses at the front of your property. Initially, that draft said that the front was determined to be within 200 feet of the center line of the corridor, but there was a little bit of concern that that may be too restrictive. And so the current version of the code, version 3 before you, actually increases that to 300 feet. So that is a very important change because it does expand the depth for which commercial uses may be provided. In addition, based on the feedback last week and some conversation with staff, we felt it was also very important to clarify how exactly that commercial use, the density of the commercial use was calculated. And so within the density part of the code, we also added a line stating that the commercial density was in essence based on the overall property, not just within the 250 feet, but that if you used all of your density for commercial use, you would have no additional density for residential. We wanted to make the same way of calculating density, which is the entire site, consistent throughout the form-based code. And so that's a minor metric issue, but it is nevertheless a change that was made to the code. One of the other things that I wanted to point out that is not a change but is very important to remind the council is that we had received some comments last week from members of the public that there was a concern about the extension of Cox Road over to New Providence Road. After talking with staff, after thinking about the importance of that link in the transportation of this particular area, we felt that from a planning perspective, it made sense for us to keep it in the plan. And so when you look at the regulating plan, you'll notice that that important piece of the visioning study continues to be in there. In addition, though, when we initially put that connection in the plan, we did make a dispensation for the property owners in that area and proposed to give them what would be called a T4 open development permission, which is actually a mixed-use development category that would allow a higher density than any of the adjacent properties as part of a recognition of that important thoroughfare. So again, that's something that we didn't change, but I wanted to provide council a little bit of background why we put it in the code initially. Now, there were some things that were pointed out last week that were internal inconsistencies in the ordinance. The first comment was that we would want to allow what are called side yard homes, or that we should allow side yard homes within what is called the T3 zoning district. Now, for those of you who don't know what a side yard home is, as you can see from the photo, it is essentially a house where one side of the home is built at the lot line. Similar to what you see a lot in Charleston and portions of Savannah. And then the other side is set back. The comment was that these should be allowed in some of the lower density residential districts, particularly the T3. And after looking at that, after looking at how big these homes actually are in most conditions, we felt that something that urban, something that high density really was inappropriate for the T3. It is allowed in the T4, and if a developer would like to do that, we feel that T4 zoning would be the appropriate use to achieve that kind of Charleston or Savannah character. And very closely related to that, we had also talked a little bit about the need for more flexibility in setbacks in the T3 district, which is, again, a single-family residential district. The concern was that if a project incorporates transfer development rights, they are allowed to build up to 5 units an acre. But the lot sizes of 70 feet wide and the side yard setbacks of 10 feet wide could make the realization of that somewhat challenging. And so what we have done is we have incorporated the identical language from Crabapple into this particular code. That language allows properties that use TDR to have shallower side yard setbacks so that the property owners have more flexibility with the layout of the actual homes. Now, why is that important? Well, that is important because when you go from a density of 2 units an acre, which is what T3 is without TDR, to a density of 5 units an acre, which is what T3 is with TDR, the orientation of your houses change and the lot sizes change. So you can actually achieve the 15 units for the overall development, or 5 units an acre, but you have to turn the homes diagonal, put the homes with the long side adjacent to the street, do a shallower lot, but still have that gracious front yard setback that's envisioned. And so we felt that in order to allow the transition from without TDRs to with TDRs, that allowing those shallower side yard setbacks would be appropriate. So in a nutshell, those are all of the changes that are in the enclosed V3 of the code that you have before you. We did not make any other changes based on feedback. We felt that a lot of the comments received last week were truly policy considerations for the City Council to take into advisement, and that we were here to help them create the code that reflects your particular direction on that. So with that said, I would love to answer any questions that you may have.
Do we have any questions? Caleb?
I haven't digested all of this. I've been on the sun too long.
I do have one or two questions. Number one, when was the last time, because I know this was supposed to be all based on the Arnold Mill visioning study. Mm-hmm. When was the last time you actually had a meeting with the community on the vision of the Arnold Mill corridor?
I will need to defer to staff on that. I know they've been coordinating all the outreach efforts. May 2014.
So it's really been a year since we've gone back to the community around the Arnold Mill area to just discuss this, exactly what their vision was for the area.
That is correct.
Okay. Also, you said within 250 feet, there would be a T4
Well,
of the main area?
actually, the way I've crafted it, it remains zoned whatever the rest of the lot is zoned.
Right.
But the only difference is that in accordance with the visioning plan, you can use the front of the property to create a mix of residential and commercial. The visioning plan talks in several parts about this mix of residential and commercial along the corridor. And so that would allow you to convert your buildings at the front to an office or a small shop. But
So
you
it
wouldn't get
be-
any additional density.
You don't get any additional density in that area for higher density residential. It would just be for commercial or office.
That is correct. If you could build, prior to that, if you could build 4 buildings, you could still build 4 buildings, but 2 in the front of the property could be for commercial uses
Okay.
or for residential if the applicant chose.
Do we have any additional questions?
No, but I think you hit it right. I think with all of the changes that we've seen here in the last year, I think the community deserves to see this again, and with all of the visual aids that go along with it.
Well, and I think the map shows how this really is an open area for development and for planning, whereas Crabapple, we were kind of filling in little undeveloped areas. So
Yeah,
this
yeah.
is very different. Okay, no further questions. We'll hear from all those speaking in support of RZ 15-11.
Our first comment comes from Dawn Housefield.
Madam Mayor, members of council, thank you again for allowing us the opportunity to speak on this issue. I too agree. Well,
State
let me back
your
up.
name and
I always
address for the
forget that. I'm
record.
sorry.
Sorry.
345 Cox Road. You've heard me saying that I'm part of a group of 50 acres at the intersection. I'm going to be referring specifically to the driving range this time. We have Mr. Mitnick here that's going to speak for the other side of Arnold Mill Road. So my specific remarks will be specifically for Danny Elkins and Chris Hasbell's driving range. And I will, since I don't repeat myself, I will stick to the high points here that we'd like to get across tonight, and that is that Danny and Chris have been working there for 20 years operating a commercial business. They have lights that are on all night, traffic, you've heard me say that before. The point that we're trying to make is that this is not about density at all for us. The densities that were placed in the ordinance, in the code by staff, are fine with us. The Planning Commission, when they went beyond our first request, which I'll come to in just a second, and went to the second and increased the density, that's never been our plan. I didn't see if Michelle came in behind me or not, but we've been talking about a project that is 4 units per acre on this since day one 2 years ago. So 5, 6, 7, 8, it makes no difference to us. That is our target. And I won't spend any time today on, because I'm seeing the clock ticking, on talking about things like side yard setbacks and things. We'll have other opportunities to talk about that. So this is really about fairness and equity. The rationale for determining what our T3 classification was is the corridor. It's an important corridor. But in that corridor, if you look on the plan, there is an epicenter of that corridor. There is a circle that is drawn there with our property right in the center. So the point that we dispute is the rationale used to say you take the whole corridor and everybody that is AG1 gets T3 or T2. Coming back and looking at our project specifically with an operating commercial development, we believe that T3 is appropriate. However, what was made in the difference made in this code is that we are limited to only 2 units per acre by right instead of 3 because it was AG1. And I might add, just very quickly, is that AG1 was the category that North Fulton used because they were well in operation before Milton was formed. And I've been in other communities before to where they use a general commercial classification with a specific use for a driving range. So it's really just the symbolism of that. But if you go look at them, they're an operating commercial business. Now, the big difference here is that if you say that there are 2 units instead of 3, it really undermines the value of the property to the point where Danny and Chris won't be able to do anything with 2 if they have to buy 2 TDRs per acre. And I'll tell you why. That costs, in today's dollars, and I'm going to back into this, it will cost $1,015,000 in TDRs to get to 4 units per acre, buying 20 TDRs. Okay? The Dorfman study that was presented to us in April of 2015 stated here in a little analysis that it was going to cost somewhere between $25,000 and $35,000 for a TDR. I asked staff to send me a list of the people that are interested in TDRs, and we proceeded to call that list. On that list right now, only one person's applied, and there's 3 TDRs that are available. Those TDRs right now are valued in excess of $50,000. When we called the next person on the list, he said, well, we've been thinking about it. How many TDRs do you need? I've got 65 acres. We said, what do you think the going rate is so that we can put pencil to paper here? He said it's going to be in excess of $50,000 because to apply to the Land Preservation Trust, it costs us $30,000 plus attorney's fees in order to even apply. So briefly, so that my partner has a chance to, my friend has a chance to be able to comment on his property, is that the TDRs, if we are required to purchase 2 TDRs per acre, it is a significant disadvantage and really does not allow Danny or Chris to develop or sell their property. They've never thought about selling it until recently, for a lot of reasons that I won't go into this. But they have not turned the back on the city of Milton. They are aware that to get 4, they will have to buy 1 TDR. And the only facts we have today are what the actual people selling TDRs have told us. And that will be a commitment of $500,000 towards the TDR program. And they know that. We've got our eyes open going to it. So the only thing we're asking you to do, please, is to be fair to us and treat us rather than saying that we only get 2 and they get 3. It's a significant problem for a person that's owned the property for more than 20 years. So if John, excuse me for being so quick, but I don't want to use up the 10 minutes. Thank you very much for your time.
I'm John Mitnick. I own the property at 12885 Arnold Mill Road. Madam Mayor, Pro Tem, and council members, thank you very much for the opportunity to address you on this important topic this evening. I would like to elaborate briefly on the requested edits that we've made to the form-based code in the order in which the items appear in the code. The first one is the architectural styles. And in this area, I'll say only the following. When the draft form-based code came out, in April, there were 7 permitted architectural styles that were based on recognized classic American architectural styles in the code. And they were there until May 20th at 8 o'clock in the evening when version 2 came out, and suddenly 5 of them had been deleted. And I will only say that they're all very important architectural styles, and I happen to have a mother who has a PhD in American art and architecture and is an expert on historic American architectural styles and also historic preservation. And her name is Barbara Mitnick, and in her opinion, those 5 styles are quite appropriate. They're obviously in use in the area and appropriate for the area because they're in the crabapple form-based code. And I'd be happy to produce my mother as a witness or to have her submit a written opinion for the record. The next edit that we asked for is the ability to use office uses on the upper floors. In other words, the 2nd and 3rd stories. We're entitled to have 3 stories in our buildings. Right now, the way the code is drafted, we can only practice office and commercial uses on the 1st floor, which leaves open the question of what we would do with the 2nd and 3rd stories. And it seems that it would be eminently reasonable to allow office uses on those floors. And if we don't use office uses there, I'm not sure what we're supposed to do with those. With regard to density, I join in Mr. Hausfeld's comments. And I'll say this. There's a consensus in the community that our T4 open properties are commercial in nature now. Even though they're zoned AG1, the reason they're zoned AG1 is because none of us, to my knowledge, has ever applied for rezoning because we were not ready to develop the properties. and there was no reason to do so. You don't rezone until you have a reason to do it, and we haven't had a reason so far. But there's a consensus in the community reflected in the visioning study report, reflected in this form-based code, which lists a host of commercial and office uses that are to be permitted in this area. There's a consensus that it's commercial by nature, by character now. It is not fair, as Mr. Hausfeld said, to require us to purchase TDRs to achieve the same level of density by right that our T4 open counterparts in Crabapple have. It puts us at a competitive and comparative disadvantage with those people just a mile down the road. And frankly, it might well spell the death knell of any commercially viable development on our properties. So I would ask that be considered in this process. I would also note, by the way, just turning to the Planning Commission. I want to mention also the Planning Commission, of course, did vote for the changes that we requested. And I want to make some final comments also about the extension of Cox Road, which would bisect my property, would run right through the middle of it. And I understand the rationale that Mr. Rossico mentioned, but I would also note that rationale is absent from the visioning study report, and in fact absent from the form-based code. And in fact, there's no connection with affording us T4 open zoning on our properties, which everyone recognizes should be commercial, and running a road, an extension of a road through the properties at the same time. He said there's a connection. Frankly, I don't see it. There's been no traffic study performed. We have no idea what the impact of the extension of Cox Road through to New Providence would do to the traffic. There's been no engineering done on the route that extension should take. Also, if you bisect the parcels on a very strange angle, if you look at the map, it's a very strange angle that the extension would take. And if you bisect the parcels in that way, we will preclude the ability of a developer to come in and map out perhaps a very large and impressive development on those properties, because now there'll be a road running right through the middle of the property. So what I would ask is that we defer on that issue until someone comes in with a definitive site plan and tells us exactly what they'd like to do with that property. So I would ask that extension be deleted for now, because the work just hasn't been done that would justify it. Thank you very much.
That is all our public comment. We do not have any in opposition.
Okay. The public hearing is now closed. Is there any council discussion?
Yeah. So, Kathy, so how would we answer our citizens' questions about the road studies and things of that nature that the gentleman just mentioned?
Well, Carter is probably a better responder to that.
Good point.
I might ask Carter to start.
Well, I think we would recognize that at this stage that's a planning document, and any of those planning documents would then move forward through some sort of engineering analysis. In this particular case, it would be one through our CTP, which is currently getting ready to start this fiscal year. Any of these road type extensions and connections would be one that we would highlight in our CTP and allow that process to go through the actual engineering evaluation of the credibility of those types of connections.
So what kind of, obviously we've had situations before where we say, yeah, we want a road to go through here. What kind of timing, if we deferred any kind of decision related to, extending Cox Road, what do you need to do to put together the information that we would need? Just from a timing point of view, how much time do you think it would take?
Oh, well, that CTP is probably going to be done in about 6 months.
Okay.
Just for also for further background, in our form-based code in Crabapple, for instance, we do show road connections in there, and they are illustrative. And the idea being that if an actual development comes along, that we would then sort of build in how indeed that road, if it could be built, would be built. So
Right.
it's illustrative purposes, but it's sort of a placeholder.
Right. So, Kathy, regarding the density issue questions that were brought up. I don't necessarily think that it's a good idea to, from the get-go, cause challenges related to how existing homeowners are viewing our idea of a vision and a plan and a form-based code. So what kind of challenges are created if we were to consider changing the zoning on those parcels? What's our motivation to make one side of the road T3 and the other side T4? What happens if we change that around or allow for T4 being existing on both sides?
And again, those are policy issues. I think Caleb tried to explain to you why there was a difference between the T3 and the T4. We originally had everything at T3, but then felt because we were putting in this illustrative roadway that would require some what's the word? Conveyance of the land for the road, and therefore to make up for that we would add additional density as a quid pro quo, so to speak. But that was the reason. We actually started out at T3 for the whole intersection. But again, it's a policy decision in terms of the amount of density. And as Caleb said also, everything is AG1, so we are upzoning. So it's just a matter of what is that determination in terms of what that upzoning should be.
Right. The final question that I'd have is, in cases for mixed use where we have 3-story structures and we're stating that commercial exists on floor 1, it's our idea that floors 2 and 3 would be residential. Is that correct?
Correct, although there is an allowance for a warrant, which would come through me, to make a decision to allow for either office or commercial on floors 2 and 3.
Okay. All right.
May I address
Yep.
the council with one other point that I think is incredibly important? There has been a misstatement both this week and last week, and Section 1.77 of the code talks about TDRs. And there is not a one-to-one relationship between TDRs and housing units. You actually get 2 additional units per TDR. We did that as an incentive to encourage them. That is in Deerfield, and that is also in Crabapple today. So this notion that to go from 2 units an acre to 4, you have to buy 2 TDRs is actually incorrect. You must only purchase 1. So I wanted to point that out because it's a big difference.
Okay.
What about the architectural styles that disappeared? What was the reason
That's a very good question. When Caleb originally put the first draft together, we had not worked on the architectural styles with the city architect. So Caleb put in all 7 styles from Crabapple as a placeholder. And from version 1 to version 2, we did work through with the city architect in terms of what we felt were appropriate styles for Arnold Mill, which are not the same as Crabapple, and hence you see what you see now, which is basically a vernacular and I think a little Queen Anne.
Probably National Folk.
Yeah, and that was about it, because it is not historical. It's really vernacular farmhouse type of architecture that you see there. So we were trying to reflect that.
On this very same point, was that point discussed in our community meeting a year ago, as far as architectural styles, what was going to be allowed?
Yeah, and Michelle, you can certainly join in too, but the visioning study did have examples of architectural styles, but we just needed to document that in terms of the guidelines that we created. But do you want to?
Yeah, the plan specifically mentions vernacular in there.
Vernacular style, which is the old farmhouse style.
Correct. But was that the only style that was discussed a year ago?
The plan did not discuss architecture. It just talked about what buildings should look like. Farmhouse vernacular style is what was mentioned in the vision study.
Rick?
So I guess the reduction from the 7 down to the 2 that's something that just recently occurred, or?
No, it was pre the Planning Commission review when we published the original draft. It was not in the original draft, but by the time this second draft came out, we had worked with the city architecture to define more specifically what those architectural guidelines should be. So it was fairly early on.
And a question to Carter, going back to the road and the reason or the need for a road. Was this anything that we'd even, I guess, in looking at future plan and road improvements, was this even on our radar?
We have talked about those connections between 140 and New Providence in the past. It didn't necessarily move forward in the previous CTP, but it is something that we do evaluate when these studies come up.
And we had looked, or specifically was Cox Road, a Cox Road extension, was that something that was being considered?
That has been considered in the past. In the last CTP, the connection was further north that they talked about. But there has been some evaluation of that Cox Road extension in the past.
Okay.
Yeah, and if I could add, Carter, when I talked with Sarah, we talked about the application that went in for the federal funding to study between Ranchette and Green Road, and so that Cox Road intersection would be something that would be studied. Now, the results of that, in terms of if we get funding or not, we wouldn't know until spring of 2016, so that's a little way out there, but it is on our radar as far as the studying of that corridor between Ranchette and Green Road.
Because Ranchette, were there potential road improvements that were being considered with
We're
Ranchette?
looking at operational improvements along the whole 140 corridor.
Okay. Because that today is a connector between New Providence.
Correct. And during the visioning study, Ranchette residents were at some of our meetings, and they would like an alternative to folks cutting through their road, their neighborhood. So that's why we considered extending Cox Road.
Do we have any further questions of staff or those speaking on this item?
I guess going back to your earlier comments, I think it'd be good if we can go back to the community so everybody gets a chance to digest this and give comment.
Well, I mean, I'd like us still to look and see if there are other architectural styles that may work. It seems like there ought to be more than two. I mean, there may not be 7, but there ought to be more than 2. I'd also like us to look at, possibility of office rather than residential on the top 2 floors. I mean, I really think if this is going to be a commercial corridor, we'll probably want to encourage office rather than discouraging it on that corridor. So I do think that we have some items that we may need to discuss further, and I also have the community look into further.
I think the gentleman, I know you closed the public hearing, but I think he's asking if you could add some additional comments.
I don't think we can, since
We
we're
can unless somebody asks him a specific question.
Okay.
So if
Can I
anyone
make a
wants
comment, Councilmember, just as maybe to get us to where we've got some direction that we can move forward with this. If I take us back to how this started, it started like a lot of good planning studies start, which is with a visioning study, which utilizes a lot of community input to then form a code that can develop on the vision. And then this goes through the Planning Commission, who make a recommendation, and then it comes to the council ultimately for their policy guidance. So it's been kind of an evolution of the process that we use that does include public input and includes it very early on. I do like the idea, if you all want to do that, of taking it back to the community and soliciting feedback now that it's kind of worked its way to where the council could take action. We've discussed, and there would be an opportunity to do that as early as the first week or second week of July. I think that's critical because we are advertised in a zoning process here that we do need to defer if we're going to defer to date certain times so that we can perfect our advertising. And that really what I'd like to do and like to offer is to bring back to the council an update of what comes out of that public meeting after we get it scheduled at the work session of July, to then suggest that maybe you defer this 1 month until the July zoning agenda.
That would be July
for
20th.
action. Those 2 dates would be the 6th is the first meeting, so not that. 13th would be the work session, and 20th, you're correct, would be the council meeting.
And could we try to have that meeting somewhere over along the corridor somewhere so that the people that are most affected by it?
I think that's most appropriate, than to have people try to come all the way here that you don't get the audience you want.
Right.
that'll give us enough time, Chris? I mean, if we have
Advertise.
those meetings, we've got to digest the feedback we have to incorporate it into an updated document.
I'm happy to move it as, out to August, too, at
No,
the council's direction.
I just don't want to put us in a position where we're gonna be behind the eight ball in terms of getting it done. Does this have to go back in front of the
Planning Commission, if there's changes.
No, the Planning Commission has turned it out with a recommendation.
Okay.
And it was not a unanimous vote. It was a very split vote, a 4-3 vote. But it has come out of the Planning Commission with a recommendation. If the council's directing us to take it back to the community, it would then come back to you all after that happens.
All right.
I can look at August dates. I mean, if you're comfortable, I guess you've got to give me some sense as to how urgent you think this topic is. If it's a 60-day urgency, that's fine with us. If it's a 90-day urgency, that's fine with us. It
Well,
just
obviously,
depends
we
on.
want to get done the work that we set out to do, but at the same time, I don't want to, given that there's been this kind of feedback received, I want to give everybody the opportunity to take a look and comment and make sure that we incorporate those comments appropriately, things like that. So
Absolutely.
I'm fine with July, but it seems to me like we might be behind the eight ball there.
Yeah, we
So
want to
then-
make sure we don't say July and
And then
then
move
end
back.
up having to defer it again.
If the council's so inclined, then why don't defer it with the direction to conduct X number, and tell me how many community meetings you'd like to have happen, and then defer it for a August 10th work session, council review, and then an August 17th action for on the zoning agenda for action.
That's good.
I think that makes sense, given what we're seeing here tonight with a lack of full council here, especially during this time of year with people on vacation. I think it's only justified to extend it for 60 days.
That makes sense.
Let's give everybody an opportunity to weigh in on it.
So should
We need to get this right.
Yeah. So should we have more than one meeting then with the community, give people opportunities so that they don't miss out?
I think it'd be nice to have 2 community meetings.
Okay,
I agree.
certainly.
And then bring it back to us at the August work session, and then to finalize what the community has said, and then the 24th, the 17th.
Yep, if somebody would wrap
Yeah.
that into a motion, that would be great direction.
So, Mayor, I'd like to move that we defer, let me get the right number. Oh,
RZ.
there it is. RZ 15-11 until a couple of dates. First of all, to review at the August 10th work session, but to be voted on and discussed at the August 17th council meeting. And in between now and then, I would request that we have a minimum of 2 meetings for the community to review and comment on the changes and the updates that we've made to the plan.
I'll second that motion.
And we have a motion by Councilmember Longoria and seconded by Councilmember Lusk to defer this for vote to the August 17th council meeting with a work session on August 10th and 2 community meetings prior to that time. All those in favor?
Aye.
Aye. No opposition, the motion carries. Will the city clerk please sound the next zoning item?
Our next item is consideration of RZ 1512 Kings Close, with approximately 525 feet of frontage on the west side, located in the 2nd District, 2nd Section, in land lots 396 and 397 by 5 Oaks Development, Inc., to rezone from AG1 agricultural to R2A residential, to develop 5 single-family residences on 6.431 acres with minimum 1-acre lots. This is agenda item number 15155. First presentation was heard at the June 1st City Council meeting. Ms. Kathy Field.
Yes, thank you, Madam Mayor Pro Tem, members of the council. The first slide here shows you the parcel outlined in red on an aerial photo. The current zoning is AG1. the future land use map shows this as private residential, which is a mistake, which I'll mention in a moment. The site plan was submitted on March 27, 2015. The subject site contains 6.431 acres and is developed with one single-family residence as well as a new street called Kings Close. The street is bisected with the Forsyth County line. It is currently zoned AG1 and is accessed through the Manor Golf and Country Club via Watson's Bend. The site is located within the private recreation designation of the City of Milton 2030 Comprehensive Plan map. The subject site was not land within the golf course and therefore was mislabeled on the plan map. The applicant is requesting a rezoning to R2A residential to develop 5 minimum 1 acre lots, single-family residences at an overall density of 0.77 units per acre. The existing home will be torn down to allow a new structure on lot 75. Based on the applicant's site plan submitted to the Community Development Department on March 27, staff offers the following considerations. We've analyzed the R2A development standards, and essentially the proposal meets those standards. Pursuant to Section 64-2392, the zoning ordinance requires sidewalks which shall be constructed in accordance with the Department of Public Works standard plan, which requires sidewalks on at least one side of the street. Within the City Code, Chapter 50 subdivisions, it is required that sidewalks within residential subdivisions be a minimum 5 feet in width with a minimum 2-foot beauty strip between the sidewalk and the curb. The site plan does not indicate the required sidewalks, but a condition is included to provide a sidewalk on at least one side of the street. The stormwater for this site will be addressed with the lake on the southern portion of the property. Homes within this development will be required to meet the Rural Milton Overlay District development standards. This includes maximum lot coverage of 25% where fronting on private streets. This is based on a recent amendment of the overlay by the Mayor and City Council. Otherwise, it appears that the development meets the requirements of the overlay. Arborist comments. The proposed rezoning will be subject to the same specimen tree preservation and tree density coverage as the existing zoning development standards. It appears that the 42-inch water oak between lots 71 and 72 should be preserved. It appears that some of the trees on lot 75 will be removed to build a new house. In terms of the impact on the Fulton County School Board, the estimated number of new students generated by this development will range between 2 to 6. In terms of the financial modeling, the net fiscal impact of this development over a 20-year period will total approximately $12,776. Community Zoning Information Meeting was held on April 27th. The applicant was present. The meeting was held at Milton City Hall. There was no one in attendance for the subject site. Public participation report. Staff received the report on May 18th. The applicant's public participation meeting was held on May 13th between 5 and 8 p.m. at the Brumble Reese offices. There was one person in attendance at the meeting. He was representing the Manor HOA and was concerned that this property is not part of the Manor covenants. The applicant's attorney and the HOA attorney are trying to work out this issue. City of Milton Design Review Board courtesy meeting on May 5th, and their opinion was that there appears to be no other solution for the site. Standards of review. The proposed 5-acre single-family residential subdivision developed at a density of 0.777 units per acre is consistent with the adjacent development to the north, west, and south within the City of Milton and the Manor Golf and Country Club, which is zoned AG1 and developed with minimum 1-acre lots. To the east in Forsyth County, it is zoned R2R, which requires a minimum lot size of 22,000 square feet. Further to the east, it is zoned MPD at a density of 1.84 units per acre. It is staff's opinion that the proposed use and density is suitable with adjacent properties within the city. Staff does not anticipate a significant impact on public services or utilities. Comments from the Fulton County Board of Education are included in the report as it relates to the estimated number of new students. It is staff's opinion that the proposal will not cause a burden on transportation facilities if approved with the recommended conditions. 3, proposed use density is proposed for single-family residential at .777 units per acre, which is consistent with the zoning. Although the plan map recommends private recreation, it is believed it should have been designated low-density residential based on the designation for the manor. This property was not a part of the golf course itself. In addition, the R2A zoning designation is acceptable within the low-density residential designation. 4, the proposed development is consistent with the adjacent development for lot size and density, but the applicant requested the R2A designation to allow smaller setbacks to be consistent with the opposite side of the road within Forsyth County. It is consistent with the 2030 future land use plan. Conclusion, the proposed 5-acre single-family subdivision is consistent with the City of Milton's 2030 comprehensive land use plan and adjacent and nearby properties. Therefore, staff recommends approval conditional of RZ 15-12. Recommended conditions. 1, to the owner's agreement to restrict the use of the subject property as follows: to single-family detached dwellings and accessory uses and structures. Also, that no more than 5 dwelling units at a maximum density of .77 units per acre, whichever is less, based on the total acreage zoned. 2, to the owner's agreement to abide by the following: to the site plan received by the Community Development Department on March 27, 2015. Said site plan is conceptual only and must meet or exceed the requirements of the zoning ordinance, all other applicable city ordinances, and these conditions prior to the approval of a land disturbance permit. Unless otherwise noted herein, compliance with all conditions shall be in place prior to the issuance of the first certificate of occupancy. B, all areas which are not part of an individual lot and held in common shall be maintained by a mandatory homeowners association, whose proposed documents of incorporation shall be submitted to the Director of Community Development for review and approval prior to the recording of the first final plat. 3, to the owner's agreement to the following site development considerations: A, minimum 1-acre lots; B, minimum heated floor area per unit, 4,000 square feet. To the owner's agreement to abide by the following requirements, dedication, and improvements: A, provide a 5-foot sidewalk with a 2-foot beauty strip on at least one side of internal streets. B, dedicate at no cost to the city at least 10.5 feet of right-of-way from the back of curb of all abutting road improvements along the entire property frontage, as well as allow the necessary construction easements while right-of-way is being improved. Proposed right-of-way shall be located no closer than 1 foot behind the back of sidewalk. To the owner's agreement to abide by the following: prior to the application for a land disturbance permit, the developer engineer shall submit to the Department of Community Development a stormwater concept plan. B, the stormwater management facility shall utilize earthen embankments where possible. Walled structures are not encouraged. And that is my presentation. I'm happy to answer any questions.
Thank you. Do we have any questions of staff?
I do.
Mr. Lusk?
You just mentioned the stormwater issue. Is this lake that's on the site or adjacent to the site existing?
Carter, can you address that?
And
It is.
okay, and I think it was stated earlier in the presentation that the lake would serve for stormwater detention. Is that right? Also, is this 5-lot development is totally separate from the manor, correct?
Yes.
And so they would have their own HOA organization.
Robin, can you want to respond a little more detail?
You'd have to ask. Actually, I think you'd have to ask the applicant to see what the intent is, to whether it would be a part of the HOA or not.
Okay.
Thank you.
Any further questions of staff?
You made a comment early on, Kathy, about, and I want to make sure I interpreted this correctly, that the owners of the golf club and the developer were trying to get together to make some decisions, but I think I took it from your statement they couldn't see eye to eye and have ceased discussions, or did I take that wrong?
Oh, it came up, I believe, at one of the community meetings, and it was our understanding that they were working through that. But again, I think that's a question for the applicant to find out the status of that. We don't really have that status report.
All right.
Any further questions of staff? If not, let's hear from those that are speaking in support of RZ 15-12.
Our first public comment comes from Scott Reese.
Madam Mayor Pro Tem, members of council, I'm Scott Reese with Brumlow Reese & Associates, doing business at 13685 Highway 9, Milton, Georgia 30004. I'm here tonight representing Five Oaks Development and Mr. Louis Renault in his application to rezone the property. I think staff has done an excellent job detailing what we're proposing here. The reason we're here is that the size of the houses has outgrown the lots with the 25-foot setbacks in the AG zoning. This particular plan is the same development guide that was proposed with the original master plan of the Manor Golf and Country Club. This particular piece of property was Dr. King's personal residence, he was the major landowner of the property that became the manor. It's a particular case where the center of the road is the county-city dividing line. The property east of the road in the same development is in Forsyth County with an R2A zoning classification that allows 15-foot side setbacks. So in trying to maintain uniformity in this particular subdivision, we're asking for the side setbacks, or all the setbacks, to be adjusted to maintain uniformity from one side of the street to the other. You will notice that on the northernmost proposed lot, we have maintained the 25-foot setback where we would not cause any undue, aesthetics to the only lots that adjoin this particular subdivision. Those two lots were also developed by the applicant at an earlier date on their frontage on Watson's Bend. We went down this road. We could have developed it AG1 and asked for variances for the side setbacks. When our meeting with staff, Robin recommended that we go this route, especially since the property in Forsyth County has these same zoning setbacks. So that's where we are. We're asking for no variances. We're in compliance with the 2030 comprehensive land use plan. We're 1 acre lots. We have the community sewer. Everything works. On our development plans, we address, we have a sidewalk shown on both sides of the street. There's just not enough room to show everything graphically and everything be clear on the rezoning plat, but we're in complete compliance with that. The development plans have been submitted. The existing lake is going to be the detention pond, so we're in agreement with staff and so if there are any more questions, I would be glad to answer those. The applicant's attorney is here if you have any questions as far as HOA matters or legal matters. That's above my pay grade, so I'll ask that you address those questions to him specifically, where we both don't go down a path we don't want to go down. So, thank you.
Thank you. Are there any other?
Our next public comment comes from Stuart Teague.
Please, Mayor Pro Tem and City Council, my name is Stuart Teague. I'm an attorney for Five Oaks Development. The issues with regard to the HOA and the golf course were in discussions with them. We actually did not know of the golf course's objection to the site plan until I believe it was Friday when they sent a letter in and copied us on it, stating that they were not in agreement with the area of the easement shown on 3 of the lots on the site plan. We actually met with the prior owner of the golf course about 18 months ago and worked out the present location that we showed on the site plan. Regardless, we don't really think that there's an issue with that easement and how ultimately it will be shown on the site plan. That's an issue that would be resolved before the final plat is approved. It's really not an issue for zoning, so we would believe that that's not something that the City Council would be concerned with at this point. But we do intend to work it out. With regard to the issue of the declaration of covenants in the HOA, we are in discussions with the HOA. I have sent a proposed agreement to include these lots within the manor community to the association's attorney. Plans currently are to have a board meeting with the HOA and go in and discuss these issues, but that is what the plan is. I guess conceivably there might be a set of circumstances where these lots would come in under a different association, but that's not really what my client wants to do. So if you have any questions, I'm more than happy to address them, but I believe that pretty much sums it up. Would like to put the constitutional objections on the record that if the rezoning were to be denied, it would be a violation of due process, equal protections, and the takings clauses of the state and federal constitutions. If you have any questions, I can answer them.
Do we have any other wishing to speak either for or in opposition?
We have one comment in opposition, and that's Mr. Dan Hewitson.
If, in light of that, I'd like to reserve the rest of my time.
Good afternoon, Madam Mayor Pro Tem, members of the council. I'm Dan Hewitson, Vice President of Operations for Club Corp. We own and operate the Manor, 15951 Manor Club Drive, Alpharetta 30004. We are not opposed to the rezoning per se. There is an existing easement which was granted to the golf course prior owner back in January 18th, 2002. It's called the King Easement Area. It's 1.32 acres. We have, as council had indicated, sent notice to them that we feel that the proposed site plan that was submitted to the City Council it impedes upon that, and we just want to ensure that if any development is allowed or any rezoning is considered, that the protection that we have for that easement and proximity to the green on that hole is preserved. So we have made council notice or aware and want to make sure that those rights are protected.
Thank you.
Thank you.
I have a question for staff.
Could I suggest maybe that we allow Mr. Teague to either make
Okay,
a
you
final
wanna go
comment or use up the last of the time, and then
Yeah.
we'll be happy to answer the questions.
I really don't have anything to add. We're going to work out the easement issue, I believe, to the satisfaction of the golf course. I personally met the prior owners out there and walked it with the developer, and what they're proposing is not something that's going to be a material issue to the golf course, and I believe we can work through that.
I just want to make sure that everyone is sufficiently aware that when the final plat is produced, that the correct golf course easement will be depicted. Rezoning plat is not at the same level that, or an exhibit that the final plat will come under. When this document was, or exhibit was generated, we were under the impression that an agreement with the prior owner was going forth with the proposed easement. But be assured, the final plat, that when it comes out of our office, will reflect, after a comprehensive title report, the correct either amended or existing golf course easement. And each lot will be developed on an individual site plan that will show the correct location of the house, the area of disturbance, and all easements of record will be shown on each individual lot. So just want to assure you that the rezoning per the case will not dictate where the area of disturbance or any interference with the golf course easement.
And staff and our city attorney can confirm that that's the proper procedure, that before any land disturbance permit is issued, that the proper easement will be reflected.
Yeah, Mayor Pro Tem, everything I heard from candidly both sides made a lot of sense to me. That number one, the zoning concept plan is just that. It's a concept plan that there are, to the extent that there are recorded easements, those just are. And that really whatever the council does is not going to be able to affect those. And to the extent that they want to go build homes, they're going to have to be mindful of any easements that may impact that. And that's just the way it is. But I don't think that should get in the way of your land use decision.
Okay. Further to that point then, is there any need for us, if we were to approve this rezoning, to base it conditional upon finalizing that easement? Or is that something that's just between them?
And I think that's going to happen, yeah, irrespective of what the council does. And so, no, I don't think that you need to do that as part of your official action, if any, this evening. Thank you, Councilman.
Do you have any other questions?
Procedurally, could we just ask the gentleman from the golf course if he has any additional comments to use up his time, and then close the public hearing, and then we'll get into questions.
Do you have any additional comments? Okay, we'll go ahead and close the public hearing then.
Thank you.
Do we have any additional questions of staff or those speaking in favor or against? You said it was your intent that the houses that would be built would be consistent with what is currently in the manor, and that eventually it would probably become part of the manor?
Yes. That's the goal. And the land disturbance permit is going to force the easement actually to be finalized before the actual placement of the house.
Actually, it'll be the final plat.
Okay.
And the easements that exist are going to continue to exist. It's just
Regardless of what we do, it doesn't
regardless of
change
what you
that.
do with the land, you could approve the rezoning that, and all of a sudden the land become not buildable because of an existing easement or a found easement at a later date. That's not your problem.
That's their issue, and where they place the houses.
Correct.
Okay. Got it.
Have any additional questions? Is there any additional discussion? Is there a motion and a second?
Madam Mayor, I'll move to approve RZ 15-12 Kings Close with approximately 525 feet of frontage on the west side, located in the 2nd District, 2nd Section, in land lots 3906 and 3907 by Five Oaks Development, Inc., to rezone from AG1 agricultural to R2A residential, to develop 5 single-family residences on 6.431 acres with minimum 1-acre lots. Agenda item number 15-155.
Second.
That's 15-12?
Yeah. Well, the agenda item.
Agenda item,
Zoning
okay,
item.
zoning item, okay.
Yeah.
I'm sorry.
The second.
Second, so we had a motion by Councilmember Lusk and a second by Councilmember Morrig to approve RZ 15-12. All those in favor?
Aye.
Aye. Any opposition? The motion carries. Will the city clerk please sound the final zoning item?
Our final zoning item this evening is consideration of U 15-03, VC 15-02, 2780 Bethany Bend by Bob Dyke to request a use permit for a daycare facility, Section 64-1809, for after-school program and summer camp within an existing church, and a concurrent variance to allow a non-opaque fence for the playground enclosure, Section 64-1809B3. Agenda item number 15156. First presentation was at the June 1st City Council meeting. Ms. Kathy Field.
Thank you, Madam Mayor Pro Tem and members of the council. The parcel is shown on the slide before you in red. The current zoning is AG1. The 2030 future land use map shows this proposed use for this area to be community facilities. This is the site plan submitted on March 27th. The subject site is zoned AG1, is developed with a 120-seat church on 7.12 acres. The proposed requests include the applicant's letter of intent explains their plans for the proposed after-school and summer camp programs. The programs will be operated by Wonderland International Learning Center. Pardon me. Students attending the after-school program will be drawn from local elementary schools ranging in age from 5 to 12. There may be some tutoring classes offered for students from middle school and high school. The maximum number of students in the after-school or summer camp would be 60. The church building has approximately 5,000 square feet. The after-school program will utilize 3 classrooms, a large society room, and 2,100 square foot sanctuary. A flat open grass area of approximately 11,500 square feet in the rear of the church will be used for outside activities. A 1,024 square foot area in the rear of the open area will be dedicated to a playground facility. The grassy area in the playground will be enclosed with a 6-foot-high decorative black aluminum fence. The applicant seeking a concurrent variance to replace the required opaque fence with an aluminum vertical rail type fence. Based on the applicant's revised site plan and revised letter of intent submitted to the Community Development Department on May 27th, staff offers the following considerations. We've looked at the standards that would be required for this use, and there's only one that they do not meet, and that's the minimum 6-foot-high opaque fence that they're requesting a variance for. The applicant meets the standards for the daycare with the exception of the request to construct a non-opaque fence around the playground, which is discussed below. BC 15-02, to allow a non-opaque fence for the playground enclosure. The applicant is proposing a non-opaque fence to surround the playground. A black metal vertical fence was proposed. At the design review meeting, they asked if a 4-board horse fence could be installed. The applicant is open to that if it looks good at 6 feet as required by the code. Subsequently, staff has found that the state does not allow for chicken wire for fencing, which is used for equestrian fencing. It is staff's opinion that installing a non-opaque fence is consistent with the goal of the city to limit opaque fences and walls. Staff recommends approval conditional of BC 15-02. The proposed site plan meets the requirements of the Rural Milton Overlay District. There are no specimen trees impacted by the development of the playground or fenced-in area on the site. In terms of the fire marshal's comments, 2 emergency exits leading from different sides of the fence surrounding the playground, but not through the building, may be required. In addition, the interior will need to be reviewed for compliance for fire code based on the educational function of the use. Community Zoning Information Meeting. On April 28th, the applicant was present at the Community Zoning Information meeting held at City Hall. There was one member of the community in attendance at the meeting. The following issues were brought up. The proposed after-school program would produce too much traffic in the area. When the church was originally approved in 1997, there was not supposed to be any additional uses. Staff notes that this was not in the conditions of zoning from 1997. The kids in the playground would disturb the adjacent neighbors. City of Milton Design Review Board meeting held on May 5th. They recommended no primary colors be used and also that a 4-board horse fence be installed unless an alternative is required by the code. Public participation report. The applicant held a required public participation meeting at the Morning Star Chapel at 8 p.m. on May 18th. There was no one from the community or other interested parties at the meeting. Use permit considerations. The proposed use within the existing church is located in the land use category community facilities on the City of Milton comp plan. The proposed use permit for daycare facility is permitted in the AG1 district when it is associated with a church and is consistent with the community facilities land use category. Compatibility with land uses in zoning districts in the vicinity of the property for which the use permit is proposed. It is staff's opinion that the proposed after-school and summer camp uses are compatible with the adjacent and nearby properties if approved with the recommended conditions. The proposed use's effect on the traffic flow, vehicular and pedestrian along adjoining streets is minimum based on the estimate. Afternoon left turns into the site are 7 for drop-off and 7 for pickup during the peak periods for the use. In addition, the average daily trips on Bethany Bend are 8,800 per day, and that meets the threshold for a left turn lane. The drop-off and pickup times will occur outside of both the school peak hour and evening peak hour. The proposed site provides adequate open space on the site if approved with the recommended conditions. The site meets the required buffers and landscape strips at the time of the approval of the use permit for the church. Since that time, the city has adopted the rural Milton overlay that requires a 75-foot undisturbed buffer and 10-foot improvement setback if additional square footage is proposed. The applicant is only adding a fenced playground area, but the site plan indicates compliance with the 75-foot undisturbed buffer and 10-foot improvement setbacks adjacent to single-family residential. In addition, the existing configuration of the site and vegetation meets the requirements of the rural view shed that require buildings to be 60 feet from the road. The following hours are proposed as indicated in the applicant's letter of intent. Monday through Friday, 2:30 p.m. to 7 p.m. School holidays, 8 a.m. to 7 p.m. Summer camp, 8 a.m. to 6:30 p.m. It is staff's opinion that the above-mentioned hours of operation are reasonable for the proposed uses and will be included in the recommended conditions. 8, the proposed use will access the site using the existing driveway, which includes a right turn lane on Bethany Bend. Utilizing the International Traffic Engineer's trip generation rates for a daycare center based on 60 students, there are an estimated 25 a.m. entering trips for drop-off and 23 p.m. entering trips for pickup. The distribution for entering vehicles is projected to be 70% westbound and 30% eastbound. Conclusion. If approved with the recommended conditions, the proposed after-school program and summer camp associated with the church are consistent with the City of Milton future land use plan policies. Therefore, staff recommends U15-03 and BC 15-02 be approved conditional. Recommended conditions. To the owner's agreement to restrict the use of the subject property as follows. A, for an after-school and summer camp within the existing building from no more than 60 students. The hours of operation shall be the following. After-school program, Monday through Friday, 2:30 p.m. to 7 p.m. School holidays, 8 a.m. to 7 p.m. And the summer camp, Monday through Friday, 8 a.m. to 6:30 p.m. To the owner's agreement to abide by the following. To the site plan received by the Community Development Department on May 27th. Said site plan is conceptual only. 3, to the owner's agreement to the following site development considerations. A, no primary colors shall be used for the playground equipment, and to allow a non-opaque fencing for the playground, which would be VC 15-02. And that is my presentation.
Are there any questions of staff?
Kathy, before we go forward with questions, could you confirm whether or not that site plan was submitted to the staff in May or in March, the 27th? I just want to perfect the record here. It said March in the presentation, but you said May both times when you were reading it.
Oh, I'm sorry. It's March.
It is March?
It's March.
Okay, so March 27th
Just
would be the site plan that you received.
Okay, that's an oversight. Thank you for bringing that up.
Bill?
Kathy, on the opaque fence, is it your recommendation then to go with a 6-foot-high opaque fence?
No, our recommendation is to allow for the requested variance, which is to put in an aluminum non-opaque fence.
Is it 6 foot high?
Yeah, Robin, do you want to speak? I think it has to be a requirement that it has to be 6 feet high.
It's a playground.
Yeah, because it's a playground.
Okay.
And the design review board asked if it could be a horse fence, and the problem is that they would have to put wire in between it, and chicken wire, and that would not be allowed. So therefore, they could not meet the conditions of the design review board requests, and so they would therefore like not to put in an opaque fence, but rather the one that uses the aluminum stakes.
With the open which?
Well, it's like it would be like the black vertical metal fence. That
Like
would,
a stockade fence?
not
Like
a
a
privacy
black rod,
stockade,
like
but
think of a wrought iron type
right,
fence.
correct.
A wrought iron
Like
fence.
swing
Oh,
Yes.
okay.
Yeah,
Yes.
but
It's-
made out of aluminum.
The state doesn't require an opaque fence. It was just in the zoning ordinance that they required an opaque fence, and so they're choosing not having to do that because, yeah.
Okay. On the opposite side of the fence, then, the neighbor's side, has any planting been addressed there?
I'll go ahead and speak to that. Basically, there already exists almost over a 50-foot buffer, so you're not going to, there's not really, it's not next to the property line. It's very far away, and it's vegetated from the original buffer requirement.
Good deal. Isn't there a state license that's required to operate one of these also?
There is, yes.
Okay. That's all I had.
Any other questions for staff? If not, first we'll hear from all those speaking in support of U15-03 and BC 15-02.
Our only public comment is from Mr. Bob Dyke.
Thank you, Mayor Pro Tem and City Council. My name is Bob Dyke, 1694 Foresta Court, Brookhaven, Georgia. Go Brookhaven. I'm a member of the church, Morningstar Chapel, and I've kind of been the guy designated to sort of spearhead this through zoning, so I've learned a lot about zoning in the last 3 months, so I've got a little bachelor's degree in it. But I just wanted to say that we totally agree with the variance for the opaque fence, and I think, or non-opaque fence, excuse me, because I think it's going to be more in tune with what the city of Milton has in terms of its architectural. And I just want to note, too, the playground is going to be way in the back of the church. So from a reality standpoint, you're not even going to see the playground or the fence, maybe a tiny bit of it from the road. So I think even though I don't think we can have a equestrian-style fence to meet state code. I think we'll still have a nice fence, similar to what Kings Ridge has around their playground, but it'll probably be 6 feet tall. And of course, we're in agreement too that any playground structure would have earth colors that would fit within the community too. So thank you.
There are no other speakers?
We have no other public comment.
Okay, then we will close the public hearing. Is there any council discussion?
Just a question, the topography there, doesn't it also kind of go down behind the church? It's a little bit lower.
As many times as I've been through there, I know I've spotted it across from North Park, but I don't know if it falls from front to back. Is this like?
Yeah, I can answer that. Yeah, you're right. If you're at the road, then I'm not sure the zoning architectural terms, but the ground goes up. Then as the playground goes, it sinks kind of towards the back.
So it would actually be almost below grade compared to if you look at the street level.
I think probably would be pretty much so, okay. Yeah.
That's what I recall.
I would just like to see one change made, and that's in the hours of operation. I think it ought to state, because Fulton County tends to change school start times and ending times, it ought to be, instead of 2:30, it ought to be whatever the ending time is for, like, earliest ending time for the 3 closest public schools, because I know there are times that the public schools in Fulton County will get over at 1:50 or at 2 o'clock, and I'd hate for kids to be sitting outside in the yard waiting till 2:30 to go in. So is that something that's possible, Kathy, to adjust? Or Robin?
Do you want to say for elementary, because that's pretty much
For
their
elementary
target.
school, yeah. For elementary school.
I'm glad you brought that up as well, because I'd like to suggest that you make one further amendment, and that's to specify that we're talking about Fulton County schools.
Yeah, Fulton County schools, yeah.
Where it does not indicate that today.
Right. Do we have any other comments? Do we have a motion?
Mayor, I move that we approve U 15-03/BC 15-02 with the changes to the language to include that opening times on school days reflect Fulton County school schedules. Elementary school schedules.
Do I have a second?
Second.
Do we have any discussion?
Does that include the recommended conditions?
Oh, correct. And all recommended conditions presented by staff.
On your second? Okay. Any further discussion? We have a motion by Councilmember Longoria and second by Councilmember Morick to approve an ordinance for the City Council to authorize, to approve an ordinance to approve U 15-03 and VC 15-02. Oh, that's the wrong one too. Sorry, I got the wrong thing here.
Here.
No,
that's right.
You were right.
Okay, 15, got the wrong numbers here, okay. 15-03 and VC 15-02. All those in favor?
Aye.
Aye. Any opposition? Motion carries. Just written it wrong in here. Okay, moving on to unfinished business, will the clerk please sound the first item?
Our first item is consideration of an ordinance of the City Council to authorize Fulton County to conduct elections. This is agenda item number 15157. First presentation was at the June 1st City Council meeting. Mr. Ken Gerard.
Madam Mayor Pro Tem, members of the council, thank you this evening. You have in your agenda books an ordinance of the City Council to authorize Fulton County to conduct elections, as well as a proposed intergovernmental agreement to address that issue. As the council is aware, later this fall, November 3rd, 2015, there will be municipal elections for which it is appropriate under Georgia Code to contract with the county, in this case Fulton County, to conduct those elections. This is an intergovernmental agreement, very much like what the city has had in place previously. It anticipates certain fees associated with that. As you'll see in the agenda packet, there is an anticipated general election fee of roughly $52,000 with a runoff election fee of roughly $48,000. There is also a chewing up process that is anticipated in the intergovernmental agreement to make sure that we only are responsible for the actual costs under the intergovernmental agreement. And with the council, this is something you've done before, and I have reviewed this agreement, or my office has, and I'm in full concurrence with it. Madam Pro Tem.
Do we have any questions? Any discussion?
Stacy or Ken, this is a prepaid fee, is it not?
Sudi could probably speak to that.
I have worked out with Fulton County that we would only pay the general election and not the special, and I have done that year to year.
That's
because
prepaid.
Yes, it's prepaid.
But there is a chewing up, though, on the
Yes,
back end.
they hold it in a reserve account, and what is not used, they refund to us within 120 days after the election is certified. So that's usually about February.
So if the election is canceled as it was in previous years, then we get the full amount?
Last year, it cost us $7,000, and that was for registration cards due to redistricting. So
a de minimis cost if it, yeah.
It could possibly cost some paper costs and some staff costs on some registration cards, but we would get the entire balance back from that.
With
Yes.
interest.
Yes.
No interest.
No interest.
Don't know
dreaming.
if I don't know if
Hey, it's worth a try.
Just a few phone calls to get it.
Any further discussion? Is there a motion?
Yes, Mayor Pro Tem, I recommend that we approve a consideration of an ordinance of the City Council to authorize Fulton County to conduct election, agenda item number 15-157.
Second the motion.
We have a motion to approve an ordinance of the City Council to authorize Fulton County to conduct elections made by Councilmember Morrig and seconded by Councilmember Lusk. All those in favor?
Aye.
There's no opposition. The motion carries. Moving on to new business, will the clerk please sound the item?
Our final item this evening is consideration of an interagency agreement between the City of Milton, Georgia, and the Greater North Fulton Chamber of Commerce, Inc., doing business as Progress Partners North Fulton, Atlanta. This is agenda item number 15167. Ms. Sarah Ladart.
Good evening. We had Bethany Esri with Progress Partners come speak to you guys at the beginning of the month, and I believe they have a copy of the agreement now. So,
Yeah, so there's not much of a presentation to make tonight other than it's a follow-up from the work session of a week ago. I did not hear or have any questions or any follow-up as a part of the meeting that we had at the work session with representatives of Progress Partners North Fulton. This has been an agreement that we've been a part of for a couple of years. As you know, it's a regional economic development tool. I can tell you, and there's been some question and some potential concern, that there's not all of the cities in North Fulton that are participating, and I think it's very, very important that if we do continue to participate, that we see a different level of service than those that aren't participating. There needs to be a distinction there, and there's really no benefit to continue to make a recommendation that we pay this money as others have chosen not to. So I put that on the record just because it is and continues to be a concern of us as we move forward with this agreement. I can tell you that I believe regional economic development, and we as a staff believe regional economic development is a very important thing. It attacks economic development differently than those that we can find within our borders, because we are, as a region, more effective, and we do play off of each other's successes. So Milton being the furthest north, we certainly benefit from Sandy Springs having a successful economic development opportunity. Mercedes-Benz landing in Sandy Springs will certainly impact Milton in the form of where people decide to live. So conceptually, it makes great sense. I guess we just throw it to the council at this point to ask whether or not, from your perspective, you want to continue this agreement for another year. I think Progress Partners has heard us loud and clear that we want there to be some equity amongst all of the North Fulton cities. If all of the North Fulton cities are, if they're not all equity, if there's not equity in pay, there needs to be, there either needs to be equity in service amongst those that are paying. I'm trying to figure out how to get the right equity word out.
Right.
I'll throw it, I guess, to the council if you have any questions, specifically of Sarah or of me or of the representatives of Progress Partners that are here as we bring forward this agreement that would continue and survive for one additional year at a cost of $25,000.
So,
Go ahead.
Chris, any chance you talk to your fellow city managers as to why not everybody chooses to participate? Because to me, it seems like it's a no-brainer. It would seem like the right thing to do, and I don't like to think that their motivation is, to get out of paying this minimal cost. So, what's the story?
Well, I think that I don't know that it's necessarily the managers that have formed the recommendation or the decision. I think there are some cities that feel as though their resources and their dollars that they contribute to economic development are better spent in-house than they are as a part of some other more regional type opportunity. And frankly, I think if you were to go to Progress Partners and website, you'd see that all of the cities are listed as cities in North Fulton as part of this North Fulton area. And I think to some, they're saying we're getting the same level of exposure. So if given the choice of either paying or not, we choose not. And I'm hoping that maybe some of that is changing. I know there's been some concept as to whether or not the three cities that are paying, if we were to take that, whatever that dollar figure is, and spread that out equitably over the 5 cities, whether or not that would incentivize everybody to get to come on board. Because if it's functioning today at $75,000, let's say, a year, it could function potentially tomorrow at $75,000 a year. 75,000 split 5 ways is a smaller number than 25,000 times 3. So for 3 agencies. So I don't know that I necessarily have an answer for you, other than I'm sure there's some politics that go along with that answer, and I'm sure there's also some there's some benefit that's been received that hasn't had to come at a cost at this point, and it's hard to suggest that we should start paying for something we might already be getting.
I agree. I think it's a great program, but at the same time, I would like to see in the future that we get something for our money that others who are not participating don't get. And I don't know that that's been the case, and we've participated now. This is our 4th year?
It would be the 3rd or 4th. I don't. Sarah, do you know off the top of our head, off of your head?
Say it started in
Off our head?
2010.
Our head thinks it's 4.
So I think, by now we will have invested $100,000 that other people haven't, so I would like to think that we're getting some benefit for it that maybe they're not getting.
Well, the line comes where we're a unified 6 cities. So if we sit there and on a map we only put the 3 cities, or Progress Partners only puts the 3 cities that give money, you're not presenting to the public a unified North Fulton. So we're the 3 cities paying into it, Alpharetta, Roswell, and Milton. We are working to try to find ways that we can get an additional benefit without it being an ununified front. I mean, that's what's tricky, and we're working towards that. We have talked a lot with you guys about that and about the splitting of the money and just trying to figure out how we can do that.
Yeah, because in some ways you can't blame them. They're
absolutely.
They're getting the same thing without having to pay $25,000, and it gives them $25,000 to use internally.
Shame on
for
them.
economic development.
Why should you buy a cow if you get the milk for nothing?
In some of the cities where they're not giving the blanket $25,000, they're helping with paying for an ad or helping sponsor a trip or sponsor in other ways, more on like a line item rather than just a $25,000 donation.
But I'm sure those don't add up to $25,000 a year.
I don't think they do. Not yet.
Don't we have another line item here for membership to the chamber?
Yes.
Yes.
That's correct.
And I'm sure I don't know, I'll ask the question, do these other 5 cities contribute with a membership to the chamber also?
With the disclaimer that I don't know with 100% certainty, my belief is yes.
Yeah.
I will say in 2012, yes.
In 2012?
That's the last time I had knowledge of that.
Okay.
Yes. All of them are chairman circle members? Okay.
So what is the function of the Chamber of Commerce then?
Would the chairman of the chamber like to answer that? Sorry, Ken Davis, he's the chairman of the chamber.
Bill, I'm, as Sarah said, the current chairman of the Chamber of Commerce, and we are the catalyst for economic development for North Fulton. We recognize the challenge that not only this council has stated, but also the other cities in terms of making their fair and equitable contribution and representation. So we're working through that with the other cities. But we try to be that umbrella organization to represent all of North Fulton from economic development perspective, bringing in the real estate developers, and attending conferences, which is where Bethany and Brandon Beach are today, with the state of Georgia trying to drive business to North Fulton.
Ken, would you mind stating your address for the record?
My personal residence is 470 Whispering Wind Lane, Alpharetta, Georgia.
Okay, so in membership to the chamber, from what I've heard you say then, you are currently and have been representing all 6 cities up here for a number of years.
That is correct.
Okay. So I have a hard time, I guess, understanding why we're paying an additional membership fee here when everybody's in this program together through our regular membership fees. And from what you've stated there, you are representing all 6 cities and generating economic opportunities for all of us. So I guess I have a hard time understanding this additional fee with Progress Partners.
When Progress Partners was formed 6 or 7 years ago, it was formed specifically for the economic development function, and we designated the funds that were contributed to that separate from a membership so that we could separate those funds to be used specifically for economic development and not in the general operations of a chamber. So the membership into the Greater North Fulton Chamber of Commerce goes to support operations and marketing of the chamber. If you give to Progress Partners, which is what this request is for, your dollars are going specifically for the economic development function, and we do not commingle those funds.
Do you have any further questions? State your name and address for the record.
Yes, ma'am. Livia Ibrahim. Work address is 11605 Haynesbridge Road, Alpharetta, Georgia.
Thank you.
And I know that geographically North Fulton consists of the 6 cities, and it's represented in that way, but moving forward, based on comments that we've gotten from these city council meetings, we are doing our best to represent only the cities that are contributing financially. And just 2 examples, if I may share with you. We are working with the Atlanta Business Chronicle, the North Fulton Market Report, and we are only including logos in our ad of the cities that are contributing, whether it be with this $25,000 ask or a line item. And another example would be we do a quarterly newsletter, and again, we're only including information on the cities that are financially contributing, so that's not how it was in the past, and that's how we're handling things moving forward.
I would say, though, if you allow someone to contribute just to the little parts that they want to contribute to, then it really hurts the whole bigger picture, because then they can just contribute to the ads that they think they're getting benefit for, but not contribute to the actual overhead and everything of the chamber. So, I mean, to me, I wouldn't let people contribute to just the side projects they want to contribute. I think it's either all in or not in, one of the 2.
And that's something that we don't plan to continue forever. I think it was just an effort to slowly try to get them on board and not to cut ties immediately and say, if you're not going to pay, you're out. It was sort of a way to slowly continue building those relationships to get them on board with the full $25,000.
I'd also say their shame is greater if you continue to, publish them as much as you publish the people that are paying. So to me, taking their logo off gives them a reason to not pay.
And that's what we're working to do.
Yeah. No, but my point is, I wouldn't give them a reason not to pay. I'm going back to Karen's point. At some point in time when you guys figure out how to do it, make it an all-in or all-out proposition, but I don't worry that their logo is displayed with our logo, even though we're paying.
Do you have any further questions?
So I guess my question is then, how are we going to, or how are y'all going to improve this situation to make it more equitable?
That is an ongoing task and challenge, Bill. And that's one of the reasons we got the interagency agreement that we've defined for the cities to deliver specifics. But it's an ongoing challenge.
Any further questions? Is there a motion and a second?
Mayor, I approve that. I move that we approve an interagency agreement between the City of Milton, Georgia, and the Greater North Fulton Chamber of Commerce Incorporated, doing business as Progress Partners North Fulton, Atlanta. Agenda item number 15-167.
Second.
Okay, a motion has been made by Councilmember Longoria and second by Councilmember Morg. Is there any discussion?
Councilmember Thurman, I'd like to, when you're in discussion, I would point maybe as one way that you, as the council, could stay engaged in this is, as a part of this agreement, if it were to approve, it indicates that Progress Partners will provide monthly written reports to the city outlining the progress they've made with respect to key performance measures and activities. I might suggest that you ask Progress Partners as a part of this motion that you'd like to have them come do that report and do it more than in just a written fashion, but actually come address the council once a month and report on their...
Maybe once a quarter, yeah.
Whatever you feel is
monthly.
appropriate. But have them actually come and report to the council on their performance related to the measures and activities that are in the contract. At least you've created an accountability loop there.
So let's see. You have to undo your second so that I can...
I'll withdraw
Can you
mine
just
so you can make
withdraw
an
the
amendment.
second? And
Yeah, so I would amend my motion to include language to ask that Progress Partners provide an in-person presentation once a quarter.
I second that.
Is there any further council discussion?
Yes. I haven't read the contract here recently. In fact, and I'm not familiar with the key performance points in that contract. I don't know if they're general in nature or if they are really specific. If we're going to have a report, I'd like to have something a little more specific than what we've gotten in the past.
I understand. I can tell you that they're in the contract and they are reasonably general, and they're general for a couple of reasons, the least of which is because of this gentleman sitting to my left who has written them in such a way as they are general enough that it's things that we can actually spend money on to be in conformance with the law and promoting ourselves from an economic development standpoint. So I can let Ken weigh in as to why they're general, but there is a reason.
That's right. I mean, the city, of course, is a subject of the laws that created, and we have only certain limited things we can spend funds on. The way we frame these provide what's called a substantive benefit to the city. And that's what we framed them that way. Obviously, they give the entity with whom we're giving the money a lot of flexibility in how those funds are spent. And so I agree with you, Councilmember Luss, that to the extent that you've got a report that's framed within those action items, it's going to be general. And so I think that's where the council may want to give staff some direction on specifically what do you want to see from the standpoint of benchmarks, et cetera, because what is going to be success is a little bit in the eye of the beholder, and I will agree with you on that.
Right. Good point.
Well, that's the beauty of having an in-person presentation. We can provide them that kind of feedback.
And you can ask questions,
Yep.
which is good. So we'll work on that. If there's anything specific you'd like to hear, just please let me know what that is, and I'll make sure that I pass that along to Sarah, and she can pass it along to Bethany to make sure that when we do the quarterly report that we're prepared for it.
Okay. Any further discussion? Do we have a motion to approve an interagency agreement between the City of Milton, Georgia and the Greater North Fulton Chamber of Commerce, Inc., DBA Progress Partners of North Fulton, Atlanta, which includes quarterly reporting
Just say quarterly reporting to the council.
to the council. All those in favor of the motion?
Aye.
Aye.
Any opposition? The motion carries. Moving on to council reports. Does anyone have anything they would like to report on? Anyone?
Can't think of it. We did a lot of work for 4 people. I'll tell you
Yeah.
that.
You did, and you did it fast. 2 hours. With a 4-item zoning calendar.
And deferring the biggest one.
We heard it for a while.
We did.
We still discuss, so.
Yeah. How about staff reports?
We've got a couple tonight. Point early on that Carter's not on the agenda tonight for department updates.
Oh, Carter.
I like it when Carter's on their agenda.
I know. Carter's gonna, but as a way of a staff report, Carter's gonna leave here in just a couple minutes. He's gonna get down to Alpharetta for their council meeting. There's gonna be a presentation on tonight about the potential connection to the Big Creek Greenway. So that's
When Carter does his presentation and answers about half the questions people email me about. So
I know. I wouldn't know what it would be like if I didn't get to give him just a second of a hard time. I do, before we start with the published ones, I do want to bring your attention to the fact that the moratorium that is in place at this point, that has this 90-day moratorium against the acceptance of applications for land disturbance permits for certain residential development areas. I can list those if you need me to list them to you. It expires on July the 12th, meaning we will have one more opportunity at a council meeting, being July the 6th, to have the council act, if they choose to extend or not this moratorium. And I don't know that I necessarily, unless you're ready to give me feedback tonight, which would be great if you were. If you're not, I understand, because I'm kind of springing this on you. But we really need to know what your thoughts are on whether or not where we are with this whole conservation subdivision ordinance process, the Planning Commission holding additional meetings, whether that's substantive and matters anymore. But I would hate to meet again, not extend it, and then all of a sudden we open the doors on July the 12th and you say, Chris, what happened? So
would that be something we'd have to give you feedback to say, extend it so we can get it, if we can actually follow through on the conservation subdivision ordinance?
Because of the fact that we are under moratorium at this point, and because we would have sufficient time and sufficient notice to extend it with a public hearing, my thought is that the city attorney would say that there's no way that you just all of a sudden at the meeting decide, gosh, we've got to do something. That we have sufficient time to correctly advertise.
It sounds like to me we need to advertise it and discuss it and make a decision at that meeting. We need to go and advertise it so that we can do that.
Perfect. That's great.
That's right.
Is that feedback? Yes?
Yep.
Okay.
Yep.
Thank you for that. The only other one I want to just keep you in the loop on and bring you up to speed on, because it drew some community attention early on, was the signs at the Children's Learning Adventure over on Cogburg Road. I met before I left town with a gentleman there who was representing their corporate office. He was a nice guy, but frankly said, I learned long ago, don't take yes or no from a guy that can't tell you yes or no. Let me put you in contact with those people. The best way to do that, he suggested, was in the form of a letter to their corporate office outlining our concerns. I sent that letter late last week. You probably saw it in your email box if you happened to spot it. You were copied on it. But at this point, the city's strong position is that the sign that appears through the front window was a material omission from the design review package that was brought forward to the city, and that my request at this point, which could get stronger than a request if it's not granted, is that they just return to the design review board and follow the design review board's direction. We're going to start there. We obviously believe we have a stronger position than that, but in the spirit of trying to navigate entering the community positive relationship with the company, Ken and I discussed a strategy that was our best first step. Just want to let you know that letter has gone out.
Since the building was not built in what we consider compliance with what was brought forward to the design review board, will a CO be issued?
I don't know that I have enough information to answer that publicly yet.
Okay.
And I don't know that I'd want to, because that also becomes part
But
of
one has not been issued.
One
as
has
of
not
yet.
been issued, and that becomes part of our strategy for bringing the building into compliance. Okay. Having said that, we've got 5 different staff reports tonight. We'll start, I believe it's Chief Stevens I saw here tonight.
Yes.
I'm thinking Chief Edgar's probably on some blue water south of here somewhere. Is that
Similar to the council missing some chairs tonight. Well, Mayor Pro Tem, council members, good evening. On behalf of Fire Chief Robert Egger, I'm Mark Stevens, Deputy Fire Chief, bringing you the fire department update. I understand that before you do have our statistics that we published, the monthly as well as the year-to-date totals. So are there any questions for me on the statistics? Yeah. If not, yeah.
Yep.
I've got a couple feel-good items that are next on your report. The first one, I'm proud to say we got our final numbers back from the Muscular Dystrophy Association on our 2015 boot drive. And as you can see, we have officially raised $74,149, which is just over a $2,000 increase over our last year's total. So we're really proud of that. Want to publicly thank the motorists, the citizens of Milton, and the visitors that travel our roadways for their generosity, as well as the efforts, the long days and hard work that the firefighters put in pounding the streets. So, again, I really believe we're making a difference, and we're real proud of that number. The second item, also kind of a feel-good thing, our technical large animal rescue team. We had scheduled 3 days of annual training with Cherokee County on Wednesday, June 3rd through that Friday, the 5th of June. And as you know, the city of Milton was the first fire department in the state of Georgia to stand up a large animal rescue team. We identified a need in our community with our equestrian population, and that's how we addressed that obvious need. I think word spread, and when Fulton County Fire Department in South Fulton County got in trouble with a bull that fell into a well, they tried everything they could do, and when it came down to last resort, they called the city of Milton. Initially, we would not respond that far, so we tried to coach them over the phone with some of the things that we learned. That was unsuccessful. Their attempts with our advice didn't work. We had all gathered that day for our annual training with Cherokee County at Cherokee's Training Center. So all of our teams, all of our equipment was staged right there. We're right there by I-75. So at the end of the day, we launched down there to give them a hand. And I'm sure most of you caught that on the news, but it was a successful rescue of a 1,500-pound bull And I've joked since then that, we've rescued, babies from swimming pools and revived them. We've saved people having heart attacks. We've put out fires and saved millions of dollars of property, but we pulled one bull out of a hole and we hit the national news. So.
And he did not look too happy about getting out.
No, he was ready to get out, though. He just wanted to know who to run over. But anyway, that story did make CNN, so we had our 15 minutes of fame. Next, we're proud of our Fire Marshal, Matt Marietta. He was selected to participate in a research project for the International Association of Fire Chiefs. It's a group called FSTAR, which stands for Firefighter Safety Through Advanced Research. And that's a national committee that they put together with leaders in the fire service. So for our fire marshal from Milton to get selected, that's a real big deal. And just a quick history on what that all means is about 3 years ago, NIST, which is the National Institute of Standards and Training, as well as Underwriter Laboratories, recognized that modern fires have changed. Basically, due to the furnishings we have now in the homes, they are synthetic in nature, nylon carpet, foam in your furniture, and the construction are wide open spaces, high ceilings, lightweight construction. All these things change the whole dynamics of how fast houses go up in flames these days. So they said, we are fighting fires today using the same tactics of yesterday. So they did a lot of science and research. They took a housing project on Governor's Island, New York, that was condemned, and they put to test what they thought was happening. And what they realized was, yes, fires do burn faster, they do burn hotter, and we have to change the tactics that we use to put them out. The following spring, at the Fire Department Instructors Conference, which is one of the major national conferences held in Indianapolis, they brought that data forward to 50,000 firefighters, and it was very difficult for the firefighters to accept what some scientists told them they should be doing. They've been taught how to fight fire a certain way. They believed wholeheartedly that was the only way you can do it. Those tactics were proven, but they were proven by the people that taught us who came through 20 years ago, and they were fighting single-story homes that were very compartmentalized. They had natural fiber furnishings and carpet, and they did not burn as fast. So the challenge since then, 3 years we've gone, is to teach the new tactics that match the current day fire, and that's what this committee Matt got assigned to will do. They will blend the educational world, the scientists, and take that information and apply it to the fire ground. So I'm very excited to see that we are making strides to catch up with the tactics that meet our challenges of today. So good job to Matt Marietta. And then finally, we have, in addition, with help from the police department, we met with Jim Craig and we conducted a tactical survey of Providence Park, basically identifying hazards, learning the topography, learning the layout, and mapping that area. So we have done that just in the past week. So we are more prepared if there's an issue at Providence Park to respond and know where we're going. Any questions? Thank you.
All right, good deal. A quick update from finance.
Good evening, Mayor and Council. I sat in the back of the room tonight because there wasn't any room up here in the front.
There's room up here.
There wasn't there? Well, we have a few things to report. New business license module is currently in place and running very smoothly. I believe that the finance staff is very happy to have that in place. I think the old system was a little more cumbersome and probably a little more advanced than what we needed it to be, and didn't produce some of the reports that we would like for it to produce. So I think the new system is working very well. Tax sale, we had a tax sale scheduled for June 2nd, and we actually did not have one because the properties that we were had up for tax sale had either paid their taxes or there was some additional work that had to be done because probably the parcels were too large to put before tax sale and has to have a whole judicial and REM process that it needs to go through. To two of our staff members went to the county last Thursday and had a meeting about the tax digest. We did get the preliminary consolidated tax digest. The numbers are up. I don't have the exact amount or percentage that they are up, but they are up. One of the things they discussed at the meeting was that countywide assessments are up a whole lot higher than they have been in the past. So they anticipate more appeals this year. I don't know what that means for the city of Milton in particular, but they didn't specify where they were increased or where they were centrally increased. So I guess be looking for the tax assessments in the mail.
How does that work for somebody that appeals their Fulton County? It automatically appeals their city when they appeal the Fulton County assessment?
It bleeds through to the city. We get the tax digest, and what happens is the assessment will automatically decrease by 15%.
14%. It's like you pay in 86% or something.
It's
85?
15%. It's 85% of the assessment that you would pay on, and then they go through the whole process. So once the appeal is heard by the Board of Appeals, then the decision is handed down to the City of Milton. We update the digest and bill or refund accordingly.
Does that mean that we may not get 15% of some of our funds until a later date once they get through the appeal process?
Correct.
Or we may never get them depending on whether or not somebody's successful with their appeal?
Correct.
Okay.
And again, I'll report on the amount the assessment has or the digest has increased when I figure that information out. One thing that the finance team is also working on is we've teamed up with Tyler Technologies to help them develop the property tax module for the current version of financial software that we're in. So we are very happy about this because we actually are able to give input on how Georgia taxes are, especially in Fulton County, because Fulton County is kind of different in how they handle taxes than they are in other counties. So this will help us to get the software better for the city of Milton, but it also in turn helps them get it better for their other customers so they can market it better. So it's a team effort. I'll be happy to answer any questions if you have any. Okay, thank you.
Thank you.
Good deal. All right, we'll move on to Dave, I guess. Information. No tie.
I'm comfortable with casual. Okay, for IT, basically it's just a real quick report. We are seeing an uptrend in the number of tickets we're getting. We had 111 last month as opposed to, I believe it was 96 the month before. That's not really showing more difficulty. That's showing more buy-in from the user base. They're getting more comfortable with the system. They're contacting them more when they have problems, not just kind of putting it off because they're not sure what to do. So we're showing that people are getting more educated in the help desk system and using it more effectively. We didn't have any outages other than normal maintenance. Everything's been going pretty smoothly, and we are moving forward with upgrades in related to the cloud deployment. I can answer any questions you have.
So David.
Yes.
Oh, sorry. No, I got to ask you a couple questions.
Oh, sure.
So in terms of the VC3 engagement, are we, so what point are we here? Have they taken over the management and the hosting of all our applications that we originally identified for them? Or are we in that process? You just mentioned there's some upgrades in the works.
Right. From the day we signed the contract with them in October, we began what was called interim support, which means they support everything we have in place. We are still in the process of getting their circuit turned up. We will have the final test and turn up on Tuesday to get connected to their data center. After that point, we'll get into a pilot program where we'll have people testing their virtual environment with the hardware we have here. So if there is any glitches or anything in implementing the new virtual desktops, they can just minimize that and go back to work the way they were. So it's we're taking a gradual approach to it, to the implementation, as kind of a migration and not just a full-on cutover.
So what's the difference between, is this dedicated circuit to their facility? Is
Yes,
that what
it is.
this is? Okay.
Right. We do have, I believe we have 5 circuits, as is right now, for phones, internet, our connection to Station 43, and so on. They will be an additional circuit that just handles traffic between here and their data center. And then they will also have a public access from the other side for people who want to work from home. So they would actually connect to the data center through that point and not through City Hall here.
Okay. Great, thank you.
Hello, how's everybody doing tonight? Good. I won't take too much of your time. I just wanted to let you know where we're going with innovation and engagement. So you'll see, first off, if you look at the numbers, that it looks like our page views just went through the, through the floor. But hopefully that's just because of us switching from the old website to the new CMS, and we'll see next month. Because either GovOffice, they were pretty consistent with the way that they were inflating those metrics, but we'll see. If they were, I don't think that they were at all, but we shall see. So we're a little over a month past the launch of the website, and everybody's been contributing to keep everything working smoothly. We're still catching little things here or there, so I really appreciate everybody who's been helping out with that. And so now I've moved on to virtualizing some of our processes. So I'm working with GovWindow, our online ticket payment provider. So we've got a test site built, and we're just working through right now, all the details of getting the, when you hit the pay button, making the code so that it gives you the total. You don't have to figure out the total, all that other stuff like that. And you should see that stuff start to fall the next couple weeks. Those dominoes start to fall. And then with the other part of it, our more heavy process items, that's what we're going to use Meritage for right now. That's the plan through our partnership with SafeBuilt. We have a meeting on the 25th where we're all going to sit around, because apparently Meritage does not have the scope of what we're looking to do. They don't have that working prototype in the community. So we're going to work with them on that and hopefully be a success story for them in that regard. So if anybody has any questions.
I guess along on that last item, Jason, so this is where we're looking at trying to virtualize the permitting and inspection process, because today I know it's a manual process. That's part of building the process, so and working with them to come up with what will be the future design.
Absolutely, yes.
Instead of just the call and...
Yeah,
okay.
Completely. I mean, what we envision with it is that it's as much as state law will allow, and as much as our budgets will allow, that it is a virtualized process that you can do through a mobile device. We might still have some time, because there's some infrastructure costs with things like plan submittal and stuff like that. But hopefully we can figure all that stuff out.
So Jason, when I read a term that says so-and-so doesn't currently have a working prototype, and then I hear that we're that, guinea pig.
We're going to be working on it.
I don't want to necessarily use the term guinea pig. I like to use the word pioneer.
Yeah, absolutely. I would too.
Okay.
I think we're bringing bold solutions to municipal government.
Oh, that was in reference to the person with the arrows in their backs. So, what was this something that was sold to us as being working and being available, and we got tricked?
It is not sold in the technical sense of the term, and that this comes as part of our contract with SafeBuilt.
Oh, okay.
So it's at this point, it's a no-cost solution.
Oh, okay. All right.
Which is why I'm not freaking out.
All right. Okay.
It's easier to be a pioneer when it doesn't cost you.
Yes.
Yeah, exactly.
Yes.
Well, at least you feel better
Very
about
much so,
it.
yeah.
Web page views. Yeah, I saw that too,
and
sort of. I thought you were going to tell us why it's so low. So are you telling me that you don't know why it's that low?
Until I get a look at next month's numbers. Because, so what happened with the site is that
so let's pretend like next month's numbers are 11,162.
Well, what that means is that for the last 5 years, essentially, that GovOffice's use of Google Analytics was artificially inflating our page views.
Okay. So the new website and the old website, are they both wired to use Google Analytics?
Yes, they are.
Okay.
We've been using Google Analytics on the site for about the last year and a half, 2 years. Before that, GovOffice had its own analytics that it used, and then it said, hey, it's a lot cheaper for us to just stick the Google code into the website. Would you mind doing that? And I said, no, not a problem at all. Now, what's really interesting with that is that they dropped by about half, which did not shock me at all, because the fact that our site would get 80,000, 90,000 views, I was somewhat dubious about anyway.
Yeah, and I wouldn't, I mean, there's a whole bunch of different ways to measure page hits and things like that, and so I wouldn't be too critical of what they did, or, I mean, because it's all sort of a figure of merit kind of a
Absolutely,
thing. So I think moving forward, as long as we're using a well-proven technology like Google Analytics, I think we could just compare everything back to May and not worry too much about it.
Yeah. Well, I mean, and the good part of it is, I do honestly believe that it will go back to what it was, because one of the things that they did was switch. They migrated the pages so that it wasn't like the old site went away and then the new site came in. They redirected every single page and moved it.
They combine.
Yeah. So, and I also know that, I don't know the exact specifics of it, but they have a little widget that runs on the client-facing side of the CMS, and it suddenly wasn't there anymore. And so we called and said, what happened to our little Google Analytics code that runs? And they said, well, Google Analytics recently changed the way they do some process or function, and didn't tell a lot of people who have websites that use Google Analytics, and so now we're trying to figure out a workaround as to what they did, which of course is always an issue if you're going to use a free tool from, a giant company. But I mean, that is the industry standard, and it's been incredibly helpful in the past. But yeah, I agree. I mean, if it doesn't go back and our number really is around that 12,000, well, good. Then we know that our number is around that 12,000. And as we move forward in the strategic planning process, we can build measures and goals and strategies around that 12,000 instead of some artificially inflated number. I mean, luckily, we're in the position that we're not judged by our bottom line on web hits, because we don't charge for advertising, right? It's merely one of the measures that we use to gauge engagement with residents. And actually, into the next strategic planning process, I'd really like to propose a few things as far as like trust barometers, that you can run in the community that might give a much more accurate representation of an outcome metric instead of a simple output metric, like how many people are going to the web page. It's how is this information sticking in their head? How are we changing behaviors by them coming to the website, so that we've got something that we can really bank on a lot more than whether or not people come to the website.
Okay.
Is there anything else? Yes, sir.
I'm probably lost something in the translation here, but can you enlighten me on this no-cost super pioneering program, Maritime?
So when we were discussing options for virtualizing our processes, there are a number of solutions out there, and they all purport to be turnkey solutions, right? Oh, you just pay us, we come in, and we'll make it all work, and you'll get your beautiful user dashboard, and everybody's going to be happy, right? And then, of course, what happens is you start to get into the nitty-gritty of that, and you were sold a different bill of goods, right? In some cases. Safe Built, however, which we already have a contract with, and we already trust, and they're already in the building, has a partnership with a company called Meritage. And Meritage and Safe Built are using their, call it the theoretical knowledge of Meritage and the applied knowledge of Safe Built, to try and build what they call Contractor Connect and Citizen Connect, which are apps that would allow essentially for the municipal business of building inspections and variances and everything like that, right? So we have been in talks with them because they came to us. They proposed that they would like to do it. They are actually already in-house here. So we have the Meritage solution. That is what our community development department is on in-house right now. So they have those in-house dashboards. They can see when things come in. What we're doing is we're taking variance requests or building inspections. It's coming to our people up front, and then they put that data into the Meritage system. And then so our building inspectors and people like that are able to see that data. So when we're able to flip on the switch to move to the internet, there won't be any huge change in here because we're already on Meritage. That's what we use right now through SafeBuild. And should we not continue a contract with SafeBuild, it is an option that is available as a a la carte item. So, and Chris could talk more about that.
I'll see if I can help out just a little bit. We had EnerGov, which was a software package. I think it was EnerGov, yes, EnerGov. Big software package, expensive software package. Software package that probably worked much better in a much larger environment because it was that robust. It was that customizable. When we looked at moving away from EnerGov and moving to something that would be more Milton right-sized, one of the options we had to move to a functioning product that worked well, that was liked by the staff that used it, was this Meritage software. It became a natural fit to go to, whether we talk about virtualization of process or not, it became a natural fit to go to take over the duties of EnerGov. And it came to us as a part of our already negotiated contract with SafeBuild. I mean, I wasn't back in front of the council saying, I want to replace this EnerGov system with something that costs $25,000. We were able to move to it. It was well respected in the industry. It was used and liked. So it was going to become our permitting software, regardless of whether or not we had them approach us at this point and say, hey, we'd like to talk to you about virtualization of your processes. We'd like to think that we're, to some degree, Pioneer can be used one of two different ways. To some degree, I'd like to think we are on that leading thought edge of doing some of these things. And if, in fact, we can work with Meritage to develop this part of this process and it works, then that's a great thing. If we invest a little bit of time into it and it doesn't work, we still have the Meritage system doing what we intended it to do when we first brought it on board. So this is kind of would be an extra step, I guess, so to speak, than what we initially brought it on board to do.
And in addition, Wade, who was here, was one of the principal architects of moving that system through in a municipal environment. So we have pretty close knowledge with some people that were heavily involved in its genesis.
I think you used the term when you were describing it earlier as theoretical knowledge. I guess I'm not familiar with that term.
Oh.
Theoretical knowledge?
So, like, you can talk about space being a vacuum, or you can build a vacuum cleaner. Right?
Okay.
Sorry, it's after 7 on a Monday.
Anything else?
Just one
Yes, sir.
question on
Yes, sir,
the
Mr.
volunteers. That's just for the number of events where we actually have citizen volunteers helping us out. Is that what that's a count of?
Yeah. Well, and you're going to see those numbers go up anyway because of the sheer number of events that we're putting on this summer with the farmers market and everything else. Yes.
Okay.
Yes.
Yeah, my guess is April was because we had Earth Day, so you had quite a few people.
Yes.
Okay.
Yes, sir. Absolutely. Okay. Thank you very much.
Good deal. Thank you, Jason. And then we're going to close out with Sam.
Last but not least, everybody's favorite, HR. The numbers pretty much stayed the same as they do most months. Couple things to point out that did change. We did have one termination. Tom Gillum in Parks and Rec took the job as Director of Parks and Rec for the City of Canton, starting up their department. Says a lot of good things about Tom and as well as our department for them hiring him and giving him that opportunity. If you look down at work comp, we did have one lost time accident. We had a police officer injured on the job during a training exercise. They're going to be out for about 6 weeks. They're expected back July 1st. Probably light duty for a little while when he does come back, but he's on the mend. It was a back injury, so he's. We'll see when he comes back. He has a doctor's appointment scheduled on the 1st of July. So those are the two big changes in my numbers. Just a couple other things to point out what's going on. Started the process of updating all of our class specs internally, working with the departments to make sure those are up to date and viable. Earlier today, we had a representative from our insurance provider come and look at all of our properties, doing property appraisals to make sure that our insurance coverage is at the proper level and that we're insuring our buildings for the right amount. And later this week, I've got a meeting to kick off our health insurance renewal with our benefit broker. So starting that process that you'll see as the budget comes forward. That's about all that I had. Anything else?
Are you looking forward to that?
Actually, I do like comp and benefits. That actually is part that I enjoy, oddly enough. My wife thinks that I'm very weird. Thank you.
Thank you.
And the
That
municipal
would be
court
the-
is just for our review.
That's right. Yeah, the municipal court and the city clerk just report on some stats at this point. The one thing we are looking at, and I'll just update the council, which I think you're probably aware, one thing we're looking at and we're talks with right now is what it would look like to move our court from this facility to the Alpharetta Travical Government Facility. So we're just starting those discussions to see what that looks like, to see if they'd have space for us. And I'll be back to the council with the report and a recommendation if it looks like it's to move forward.
I'm assuming we don't need any executive session?
No executive session tonight.
Okay. Then we have a motion to adjourn.
Motion to adjourn.
Second motion.
We have a motion to adjourn by Councilmember Morgan, a second by Lusk and Longoria in unison. All those in favor?
Aye.